Good afternoon, everyone. My name is Ethan Wright. I'm a 2L here at Duke Law, and I, along with my fellow coordinators, Savannah Best, Rachel Novoreski, and Margaret Anderson, would like to welcome you to the final round of the 2017 Hardt Cup Tournament. Before we get started, just please make sure your cell phones are either off or silenced, and once the arguments begin, please keep your seats. The Hardt Cup is our first-year moot court competition, and for many competitors, it's their first introduction to oral advocacy. Putting it together has been a labor of love, and it could not have been done without the help of faculty, practitioners, and the clerkship office. Thank you for your patience, your counsel, and your unerring dedication to keeping Duke excellent. We are also honored to welcome as our judges today, Judge Stephanie Seymour of the 10th Circuit Court of Appeals, Judge Terrence Boyle from the District Court for the Eastern District of North Carolina, and Judge Lawrence Vilardo from the District Court for the Western District of New York. Arguing today are Meredith Compton for the petitioner, Shaquille Robinson, and Kyle Nodes for the respondent, the United States. Meredith comes from Memphis, Tennessee. She graduated from Vanderbilt University in 2016 with majors in political science and health policies and economies, and has become a part of the Health Law Society and the Mock Trial Board here at Duke. Kyle is from Holmdel, New Jersey. He graduated in 2016 from Villanova University with a major in political science, and he is part of the Veterans Assistance Project here at Duke Law. This year's case is about the limits of the Fourth Amendment. In West Virginia, in 2014, police received an anonymous tip about a man loading a gun in a 7-Eleven parking lot before getting into a car. Officers quickly found the car, pulled it over for a seatbelt violation, and asked whether the passenger, Shaquille Robinson, was carrying a weapon. When he did not answer, he was frisked, his gun was found, and he was convicted of being a felon unlawfully possessing a firearm. Because West Virginia permits the concealed carry of firearms, he argued that the search was not lawful under the Fourth Amendment. When the Supreme Court decided Terry v. Ohio in 1968, it created a new body of jurisprudence specifically for this, to balance our rights under the Fourth Amendment with concerns for the safety of our police officers. Shaquille Robinson's appeal presents the issue of how a state's decision to broadly permit the concealed carrying of weapons may impact that calculus. We hope you enjoy the competition, and good luck to the competitors.
All rise. The Honorable, the Chief Justice, the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay. All persons having business before the Honorable, the Supreme Court of the United States, are admonished to draw near and give their attention, for the Court is now sitting. God save the United States and this Honorable Court.
Good afternoon. We will hear the case of United States versus Robinson, and we'll hear first from the petitioner for Mr. Robinson.
Madam Chief Justice, and may it please the Court, my name is Meredith Compton, counsel for the petitioner, Mr. Shaquille Robinson. With the Court's permission, I would like to reserve 2 minutes for rebuttal. Your Honors, this is a case about preserving the Fourth Amendment's prohibition against unreasonable searches and protecting individuals from arbitrary governmental intrusions. Today, we respectfully request that this Court reverse the Court of Appeals for the following 2 reasons. First, the phrase armed and dangerous, as it appears in Terry v. Ohio, is a disjunctive test, requiring a reasonable suspicion that an individual is armed and also dangerous. Second, because West Virginia has determined that carrying a concealed weapon is not inherently dangerous, the officers in this case had no reasonable basis for conducting the frisk of Mr. Robinson.
Has West Virginia actually made a determination that carrying a gun is not dangerous? They
Yes.
just made the determination that if you have a license, it's legal to carry one.
Yes, Your Honor, that it is lawful when you have a permit to carry a concealed weapon, and that is a determination that guns are not inherently dangerous by allowing individuals to safely carry them in the state of West Virginia.
The informant reported that the informant saw him loading the weapon. Isn't that something that makes it determinative that he is dangerous?
No, Your Honor, that is perfectly lawful in West Virginia, and under this court's determination in Terry v. Ohio, there must be a reasonable suspicion that an individual is armed and presents a danger, and that fact alone was not sufficient to justify a frisk on the basis that he presented a danger.
Does it matter where this takes place? So suppose an informant says, I saw someone loading and concealing a gun in a schoolyard. Make a difference where it happens?
Yes, Your Honor, that would be a factor to take into consideration, but simply the factor in this case that it was a high crime area was not sufficient to justify.
Why not?
Because, Your Honor, it cuts both ways. It could indicate that an individual is engaging in suspicious behavior, but also that an individual is engaging in wholly innocent behavior. That because it is a high crime area, individuals do not feel that they're protected, so they carry concealed weapons to defend themselves against that potential.
Is there a different standard in a high crime area from any other area?
No, Your Honor, that's precisely the concern, that if we give substantial weight to the fact that it was a high crime area, we have the potential of imposing a substantial and disproportionate burden based on a geographic location.
Why isn't it just as likely that this man didn't have a license and was unlawfully carrying?
Well, Your Honor, that might be a potential for the police officer to believe that the individual doesn't have a license, but there is no evidence to suggest that Mr. Robinson didn't have a license and wasn't lawfully exercising his rights in West Virginia to carry a concealed weapon.
So is the police officer supposed to wait until he finds out whether this armed man has a license or not before he takes action?
Yes, Your Honor, under Terry v. Ohio, there must be a reasonable suspicion that an individual is armed and also presents a danger. And typically when this court comes across a conjunction like and that separates two terms, they construe each term as being an independent element, meaning that armed is separate from dangerous, that just because an individual is carrying a concealed weapon, especially in a jurisdiction where that is lawful, does not mean that that individual poses an inherent danger to the police officer. There must be additional evidence, specific articulable reasons, to justify such an intrusion on an individual's personal security. Now, this court in Adams v. Williams held that those specific articulable reasons were the fact that the individual was acting hostilely towards the police officer and refusing to exit the vehicle.
Was the passenger going to be the subject of an arrest, or was it just the driver?
In the case of Adams v. Williams, in this case, the passenger was not pulled over. The passenger was pulled over for not wearing a seatbelt, which is not an indication of a dangerous offense. And he was asked to exit the vehicle, and he exited the vehicle per the officer's request.
Was he being arrested or given a citation, or was it just the driver that was being arrested?
Neither of them were being arrested. They were pulled over for a traffic violation, but upon being pulled over, the police officer did ask Mr. Robinson to exit the vehicle, which he complied with. And under the United States v. R v. Zoo, we do have to consider the totality of the circumstances in order to determine whether a search is reasonable under the Fourth Amendment. But even when we consider the totality of the circumstances, there was not sufficient evidence to suggest that Mr. Robinson posed any sort of threat to the police officer. The informant's tip to the police officer was information about lawful behavior. Mr. Robinson in West Virginia was perfectly within his rights to carry a concealed weapon in public.
Well, lawful, but perhaps dangerous. So you get a very specific report: the color of the car, the race of the driver, the gender of the driver, the race of the and the gender of the passenger, and that he is carrying a concealed and now we know loaded weapon. Isn't the result of what you're suggesting going to be endangering police officers on the job every day if they can't look for these kinds of things?
No, Your Honor, they're absolutely allowed to look for those kinds of things when they have a reasonable suspicion for believing an individual poses a danger. Simply being armed, even with a loaded weapon, is not sufficient under Terry v. Ohio. We understand that police officer safety is an important interest, but so is protecting the Fourth Amendment.
But so it's the rule, the constitutional rule is going to be different in West Virginia than it is in New York that doesn't have a conceal and carry law. Is that what you're telling me?
No, Your Honor, the rule doesn't change. What changes is the rational inferences we can draw from the fact that an individual is armed. In Terry v. Ohio, that jurisdiction prohibited carrying of concealed weapons. So the fact that the officer had a reasonable basis for believing the individual was armed allowed that officer and this court to draw the rational inference that they might be posing a danger to the police officer.
Would it be different if the passenger put a knife in his pocket or had a baseball bat in his lap?
No, Your Honor, it wouldn't be different if that was the only factor that had changed. Again, there wouldn't be any evidence, as there was in this case, of any potential danger to the police officer. There must be additional evidence, specific articulable reasons, to justify such an intrusion into an individual's personal security. A generalized fear of danger of guns or of knives is not sufficient. Under Terry v. Ohio, there must be particular objective reasons to ensure that we aren't allowing for unbridled police discretion, that we're ensuring that the only parts of the calculus under Terry v. Ohio are these objective reasons to justify such a personal intrusion. To authorize otherwise would enable police officers, based on subjective impressions or hunches, to conduct these Terry frisks, and that is not what this court held in Terry v. Ohio.
Why should we assume that just because West Virginia says it can be lawful to carry a concealed loaded weapon, why is that necessarily a determination that a gun is not dangerous? I mean, that's counterintuitive, isn't it?
No, Your Honor, because when you're approaching an individual who is engaging in perfectly lawful behavior, you can't draw that inference that because they're carrying a concealed weapon within their rights in West Virginia, that they automatically pose a danger to the police officer.
You're conflating unlawful and dangerous, aren't you? You're saying that if the concealment of the gun is unlawful, that makes it dangerous. Why isn't concealment of a lawful gun just as dangerous as the concealment of an unlawful gun? And are you really arguing for a change in the standard from armed and dangerous to armed and unlawful?
No, Your Honor, but the court in Terry v. Ohio distinguished the fact that because the individuals were engaging in lawful behavior, because they had the concealed weapon, that was a distinguishing factor in those circumstances in that jurisdiction. The court in Adams v. Williams, the distinguishing factor was the fact that the individual was hostile towards the police officer, refusing to get out of the vehicle, instead chose to roll down the window, where the police officer could no longer see the movements of the individual in that circumstance, and thus they posed a danger to the police officer. And in Maryland v. Wilson, the officer observed the fact that the passengers were shaking, they were sweating, they were nervous, they were ducking, avoiding eye contact. That was abnormal behavior, justifying the police officer's request that that passenger exit the vehicle.
But didn't the record here suggest that when he was asked whether he had a weapon, that he behaved in an unusual manner?
No, Your Honor. The fact is, according to the record, it was mere seconds after being asked whether he had a weapon that the frisk commenced. Now, in West Virginia, he had no legal obligation to answer that question. They do not impose an affirmative duty on its citizens to answer that question. But despite that fact, there was no indication he even had the opportunity to answer that question. Mere seconds is not enough time to answer that question.
Yes or no? Do you have a gun? Yes or no?
Well, Your Honor, the fact is he made a look and then the frisk began, and that subjective impression of a weird look is not permitted in the calculus under Terry v. Ohio. Mr. Robinson was not given the opportunity to answer that question, did not have to answer that question, and therefore the fact that he was unable to answer that question should not be a determinative factor that he posed a danger to the police officer.
And why is the weird look not enough?
Because as the court and the district court, the Court of Appeals and the Court of Appeals en banc panel all held that subjective impressions are not sufficient, that we have to consider objective and particular reasons to justify such a frisk. And the fact is, in the interactions with the police officer, based on the officer's own testimony, both the driver and Mr. Robinson were wholly cooperative and compliant with the officer's request. They were not nervous, as was the case in Wilson. They were not hostile or evasive, as was the case in Adams, and they were not engaging in any sort of unlawful behavior, as was the case in Terry v. Ohio. The facts that the officer had when he conducted the frisk were the fact that Mr. Robinson was carrying a concealed weapon within his rights in West Virginia. The fact that he wasn't wearing a seatbelt, which is not a dangerous offense.
I'm having trouble seeing why there's a presumption that he has a license. Why isn't there a presumption that he doesn't have a license?
Because if the presumption is that individuals carrying a concealed weapon in a state like West Virginia that they don't have licenses would authorize police frisk in any situation where there's a lawful stop and an individual is carrying a weapon. That would open the door for unbridled police discretion, that at that point a police officer just has to suspect that an individual is carrying a weapon, and then they can pick and choose who to target for frisk. That has the potential for having a substantial impact on certain groups of people or allowing police officers based on implicit bias or personal prejudice to conduct these frisks, which is not authorized and not reasonable under the Fourth Amendment or under this court's reasoning in Terry v. Ohio.
What about the language in some of the Supreme Court cases that recognize that a traffic stop has some inherent danger, particularly when there are two people in the car, based on statistics about possibility of the police officer getting shot?
Yes, Your Honor, traffic stops do present a danger, but it's a danger in terms of the circumstances, that any traffic stop introduces a potential danger, but it doesn't tell you anything about the particular danger that the individual poses, which is the test under Terry v. Ohio, that the individual has to pose a danger or a threat based on a reasonable suspicion in order to justify an officer patting an individual down. This intrusion into their personal security must be based on the individual propensities, based on the reasonable suspicion that that individual poses a danger. So while police safety in traffic stops is certainly a reasonable interest that the government holds, it is not sufficient to justify such a personal intrusion. There must be more than a generalized risk. And in this particular case, there was nothing more than a generalized concern for police safety. There was no specific articulable reasons to believe that Mr. Robinson posed any sort of danger to the officer. We're asking that this court uphold the integrity of the Fourth Amendment and protect against unlawful searches like the one that happened in this case. We must require that there be specific articulable reasons to protect against this unbridled police discretion and to protect against subjective impressions or implicit biases from invading the calculus to justify such an intrusion into an individual's personal security. Mr. Robinson was simply acting lawfully and carrying a weapon in West Virginia. He was cooperative with the police officers, and despite those facts, he was subject to a frisk in violation of his Fourth Amendment rights. We cannot allow police officers to have this unbridled police discretion and to potentially introduce subjective impressions or personal prejudices when they're deciding who to frisk. Therefore, we ask this court reverse the Court of Appeals. Thank you.
We'll hear from the United States.
Madam Chief Justice, and may it please the Court, my name is Kyle Nodes, counsel for the respondent, the United States of America. Your Honors, this is a case about our law enforcement officers' need to be able to ensure the safety of themselves and the people around them. The respondent respectfully requests that this Court affirm the Fourth Circuit in denying petitioner's motion to suppress and upholding his convictions. The Court should affirm for two reasons. First, the fact that an officer reasonably believes an individual possesses a concealed firearm is sufficient under the framework established by this court in Terry v. Ohio to believe that that individual is armed and dangerous. Second, even if the officer...
Always? What if the person is walking down the street and has a consensual encounter with the police and is carrying a concealed weapon? Is that reason to search him?
Well, Your Honor, under the framework from Terry v. Ohio, the officers first have to have a legal reason to stop the individual, believing that he may be committing a crime. Now, a simple interaction with an officer on a street corner may not give them that first legally sufficient reason to engage in the stop, which would then give them permission to decide whether or not the individual is armed and dangerous.
Shouldn't it make a difference whether it's a minor traffic stop versus suspecting somebody has heroin in the car, for example?
No, Your Honor. As this court made clear in Terry and then later in Adams v. Williams, the point of a Terry frisk is to ensure that the officers are safe during these interactions. The point is not for the officer to look for further evidence of a crime or criminal activity or any criminal activity the individual may be engaging in later.
No, but the point is the situation is much more likely to be dangerous if the person is a druggie or carrying drugs, more likely to react. This guy was just not wearing a seatbelt.
Yes, Your Honor. But it's important the court recognize today the inherent and unique danger involved in firearms. Now, guns, by their very purpose and design...
Did the rulings in Heller and McDonald, did that change any of this calculus? Did it invest citizens with a more superior right to individually possess a firearm?
Your Honor, those rulings both made sure that individuals do have a fundamental right to carry a firearm, but those rulings also included a fundamental understanding that firearms are dangerous. In Heller, the court made clear that part of the basis for such a right was the right to self-defense, which recognizes in and of itself that guns can be used in a deadly fashion. Now, officers approaching situations like this, where they've made a legal stop, have a legally sufficient basis to be interacting with the individual.
Well, they were looking for this car. They'd gotten a call from a citizen, an unknown citizen, giving them a profile, and they were looking for this car. They didn't stop it because it had a seatbelt violation. They stopped it because that was the car they were looking for.
Yes, Your Honor, but because of the seatbelt violation, the officers had a reasonable basis for stopping the individual in the first place. Now, this court has held that pretextual stops are lawful, and the petitioner does not argue that the stop was unlawful or that Mr. Robinson was not reasonably concluded to be dangerous.
But they know that he's armed. How do they know he's dangerous?
Your Honor, that comes down to the fundamental basis of guns. Now, firearms by themselves are dangerous. Now, by their very design, they're deadly weapons that can be used in a very quick fashion, can be used quickly enough that officers may not have enough time to prepare or protect themselves or the people around them.
Yeah, but citizens have a constitutional right to have a firearm.
Yes, Your Honor. Now, in any such case, the court is going to have to balance such fundamental rights against the compelling interest on the other side. And there are few interests more compelling than officer safety. Now, we ask law enforcement officers to put their lives on the line on a daily basis in interactions with individuals that they do not always know what their motives may be. And when the officer has a legally sufficient basis for making such a stop.
You're arguing for no firearms in America.
No, Your Honor. Citizens have a fundamental right to carry a firearm, and the government absolutely acknowledges that. The only point here is that when an individual is carrying a firearm, that individual may pose a greater danger to a law enforcement officer than someone who is not.
Well, in fact, your argument is if they're carrying a firearm, they are dangerous.
Yes, Your Honor.
Every person who carries a firearm is dangerous.
An individual who is carrying a deadly weapon when interacting with a law enforcement officer is providing a reasonable basis for that officer to believe they.
So when we said in Terry, armed and dangerous, we were being redundant. We really didn't mean armed and dangerous, we just meant armed.
No, Your Honor. In Terry v. Ohio, they were pointing out that the basis for concluding that an officer can stop and frisk such an individual was because they are armed and that presently they were dangerous to the officer.
Right, but they have to be both armed and dangerous. In fact, the language in Terry is not armed and dangerous. It's armed and presently dangerous, right? The adverb modifying only the second of those, that is dangerous. So isn't your argument that the two of them mean the same thing, that armed is necessarily dangerous, in conflict with the language of Terry? If they meant what you said, they would have said presently armed and dangerous, but they didn't. They said armed and presently dangerous. Why doesn't that tip the balance in favor of a two-part analysis? Are they armed and are they dangerous? Not this one-part analysis that you're telling us to adopt. Are they armed and dangerous?
Well, Your Honor, in Terry, they actually used a few different forms of language in describing the test. They did say armed and presently dangerous. They also used the language armed and thus dangerous, which in that situation would imply that the individual was dangerous because of the fact that they were armed.
You say armed and presently dangerous twice, right? They say it in the conclusion. In fact, they say it in the holding. They say we hold armed and presently dangerous, right?
Yes, Your Honor. Now, even if this was a two-part test and the fact that an individual is armed does not mean they are dangerous, it's important the court note that firearms are unique amongst the weapons an individual may carry with them. Now, guns, by their very nature, are deadly. They're different than other weapons. They're different from knives, clubs, or other concealable weapons an individual could use to harm an officer. And officers who are put in such situations where they're engaged in a legal stop and engaging with an individual with a reasonable suspicion that they had the right to stop them in the first place need to have some form of deference and some room to decide that that individual, because they are carrying a deadly weapon, may present a greater danger.
But they're different in West Virginia because they're legal, right? They're different in West Virginia because it's legal to carry them concealed. That's what makes them different, right?
No, Your Honor. As this court made very clear in Terry and Adams, the legal sufficiency of the concealed carried firearm is irrelevant to discussion of whether or not the individual is dangerous. Now, the purpose behind a stop and frisk under the Terry framework is to ensure the officer is safe. It's not to look for evidence of a crime. So as this court stated in Williams, the fact that the individual may be carrying the concealed carry weapon legally is entirely immaterial to the discussion of whether or not the officer can conclude that that individual is dangerous.
Well, if it's just a matter of safety, why are we worried about suppressing it? If all you're worried about is police safety, they can check anytime they want. The evidence doesn't come in. If it turns out he's got an illegal firearm, it doesn't come in. but they're going to be safe. They're going to be safe because they can ask the question.
Your Honor, if we allowed evidence got in this way to be suppressed, we'd be asking officers to make a decision in the moment whether or not they want to keep themselves safe or whether or not they want to give up the ability to effectively enforce the law and stop crime. Now, officers who make the decision that they believe a situation is dangerous and them or people around them may be in greater danger need to know that when they make the decision to frisk the individual, to look for a firearm or another weapon, that they can still effectively enforce the law. And if we ask officers to balance evidence that may be suppressed in court and letting an individual go if they are committing a crime against their own safety, officers may, in certain situations, decide to put themselves at greater risk to make sure that they are effectively enforcing the law and keeping civilians safe.
Let me ask you this. Suppose when they ask him, do you have a gun, he says, yes, I've got a gun, and it's legal to have a gun. I've got a gun concealed at me. It's legal to have a gun concealed at me in West Virginia. What can the police officer do then?
Well, in that situation, Your Honor, the officer has a few different avenues. They can ask whether or not the gun is a permit, whether he has a permit for the gun under the state law.
Won't answer that.
Well, Your Honor, in that situation, the officer needs to have some form of deference and some room to decide that they might not believe the individual, or they may believe that even though the gun is held lawfully, the individual still poses a danger to them. Now, the Terry stop is not meant to look for evidence of a crime, and the fact that the gun may be held legally is irrelevant to discussion. Guns are deadly weapons, and even if an individual possesses it legally...
So if you legally carry your concealed weapon, you better wear your seatbelt. Because anytime an officer stops you for a minor traffic violation, he's going to frisk you. Is that where you're going?
No, Your Honor. In a situation like this, the important point is officer safety. Now, there may be situations where individuals feel that their rights are being infringed upon, but it's important to balance this against the compelling interest in officer safety. Now, we're asking police officers go out on a daily basis and put themselves in risky situations with individuals they don't know, with motives they're unaware of, to put themselves at greater risk.
They knew what they were looking for. In this case, they had a bolo, be on the lookout for a African-American man, probably with a gun in his pocket, and a Caucasian woman operating a car of a certain definition, and that was what they were looking for. They weren't coming upon a scene where somebody didn't have their seatbelt on. They were out there looking for that. How do you explain that?
Well, Your Honor, even if the fact the individual had a firearm weren't sufficient on its own, when we look at the rest of the evidence surrounding this stop, under the totality of the circumstances, there was a sufficient basis for the officers to have concluded that Mr. Robinson may have been dangerous. Now, the officers first knew that the individual may have been carrying a concealed and loaded firearm.
So if they had their seatbelts hooked, they couldn't stop this car. Is that what you're saying? They found the car, they had all the prior information, and they just couldn't stop it.
Yes, Your Honor. Under the framework established in Terry v. Ohio, the officer needs to have a legally sufficient basis to stop the car in the first place. They can't simply go around looking for individuals they believe have guns.
But that's what they were doing.
Mm-hmm.
Well, Your Honor, they had a reasonable and a legal sufficiently basis to make the stop in the first place.
That was opportunistic. I mean, they were going to find this car. That was their goal.
Yes, Your Honor, but pretextual stops in this manner have been upheld by this court before.
This is pretextual to find a gun, and they use the gun or the possibility of him having a gun to do the frisk. There's something circular about that, isn't it?
No, Your Honor. In a situation like this, we were to tell the officers that even though they have the gun, they're not allowed to frisk if they make a legal stop, would essentially be telling them they couldn't make that stop in the first place. Because once the officers had decided the individuals were not wearing seatbelts and were committing a traffic violation, if we told them that they had to put themselves at greater risk when they went to enforce seatbelt laws and make the stop, we'd be telling them that the fact that they believe that they're in greater danger doesn't matter in that situation. Now, once the officers have the legally sufficient basis and have passed the first standard under the Terry framework, it's important that they be able to make sure that they are entirely safe, or as safe as they believe they can be when engaging in that legal stop.
Shouldn't the officer at least be required to give him a couple seconds to answer the question, do you have a gun?
Well, Your Honor, that would be fantastic if that could be the case in every situation. But the reality is that in situations in which a firearm is present, officers might not have that type of time. Now, guns can be used quickly and in a deadly fashion, and officers have to make split-second judgment calls when they're making such legal stops.
Usually there's some reason for that. What you're saying basically gets back to if you're carrying a concealed weapon and the officer can tell from a bulge or something, assume he has no knowledge of anything, but he sees the bulge in your pocket and you could legitimately stop for a seatbelt violation, you're going to get frisked.
Yes, Your Honor.
So you better hide your gun somewhere? Really conceal it?
Well, Your Honor, the fact that individuals may be able to conceal the weapon more effectively goes to the exact point of why it's important that officers be able to make a call that the individual is dangerous if they know they have a concealed firearm. Now,
Do we know what percentage of people in West Virginia carry concealed firearms?
no, Your Honor, that's not in the record.
Okay, if we find out that 90% of people in West Virginia carry concealed firearms, can we do a stop and frisk every time we stop anyone for any legitimate basis?
No, Your Honor. The government acknowledges that officers would need a second sufficient reasonable basis for concluding that the individual may have.
90% of the people are walking around with guns in their pockets. What could be more reasonable than that?
Well, Your Honor, even if that was the case, in this situation, the officers have a better reason than that for concluding that Mr. Robinson was armed and dangerous. Now, they had been told by the 911 caller that Mr. Robinson was seen in the parking lot of the 7-Eleven loading, concealing the firearm in his pocket.
Perfectly legal if you have a license.
Yes, Your Honor, but the legal sufficiency of the carry is irrelevant to the question of whether or not the individual is dangerous. Now, by the time the officers had stopped Mr. Robinson in the car and had approached the vehicle, they already knew that the first 3 points of the anonymous caller's tip had been proven accurate.
So if the anonymous, I want to see if I understand this. If the anonymous caller's tip was, there's a guy who's got a legal permit to carry a concealed firearm, and I just saw him load the firearm and put it in his pocket, and I know he's got a permit because he's a friend of mine, and you stop him for a seatbelt violation, you can still frisk him?
Your Honor, if the officer believes the individual has the firearm, yes, it's important that officers be able to make sure that they are safe in these situations. Now, under the Terry framework, the officers need to have the legal basis for making the stop in the first place. But once they're in that situation, officers need to be able to have some level of deference given to them in deciding whether or not they believe the situation or the individual have become dangerous. Now, in these scenarios, officers have to make split-second judgment calls. And it's easy to go back afterwards and decide that the officer may have been too quick in making such a decision. But in the moment, officers need to have some room, some leeway in deciding that they know that this individual may be carrying a loaded and concealed firearm. They know that guns are deadly. And they believe that in this specific scenario, the individual poses a danger to them, perhaps their partner, the other people who are in the immediate area. So in that scenario, officers need to be able to come to the conclusion that individual is dangerous and do the Terry stop and frisk to make sure that the situation is under control. Now, Your Honors, it's important to remember here that the focus of this case is on officer safety. What we need to focus on here is the fact that law enforcement officers put their lives on the line on a daily basis. They need to have room and time to make a decision that they believe that an individual who is carrying a loaded firearm in a situation like this.
We're talking about a constitutional right here, which the Supreme Court recognizes is an important right not to be searched unreasonably. And you want to, where does that fit into this?
Your Honor, I see
There's no exception for officer safety in the Constitution.
Your Honor, I see that my time has expired. May I briefly conclude? Your Honor, the court has to, in situations like this, balance that fundamental right, which the government absolutely acknowledges, against the interest on the other side. In a situation like this, you're not going to find an interest more compelling than making sure law enforcement officers who put their lives on the line on a daily basis are as safe as they can be while still effectively enforcing the law. For the foregoing reasons, the respondent respectfully requests this court affirm the Fourth Circuit. Thank you, Your Honors.
Thank you. Some reply?
May it please the court? Under the government standard, any individual exercising his or her Second Amendment rights could be subject to a lawful frisk. That is not the standard or the balance that this court struck in Terry v. Ohio. As Justice Vilardo indicated, the court in Terry v. Ohio held that an individual must be armed and presently dangerous in order to justify such an intrusion into an individual's personal security. While police officer safety is certainly an important interest, there also must be a reasonable suspicion that an individual poses a danger to justify a frisk under Terry v. Ohio.
If we adopt your position, police officers are going to die. Isn't that a simple syllogism that's going to happen? Your argument is going to lead to more police officer deaths.
No, Your Honor, because if there is a reasonable suspicion that an individual poses a danger, that police officer is certainly allowed to conduct a Terry frisk.
I understand that, but police officers are going to err in favor of not doing the frisk, and one of the police officers is going to be wrong, and somebody's going to pull out a gun and shoot him. Shouldn't that be something that concerns us?
It is a concern, Your Honor, but under Terry v. Ohio, there must be that disjunctive test. There must be evidence that an individual is dangerous, or you run the risk of allowing for unbridled police discretion.
The other side of that coin is that citizens who are exercising their Second Amendment right to have a firearm are going to be searched unreasonably.
Exactly, Your Honor. That's the precise problem if we uphold the government standard that just because you're lawfully exercising your rights that you're now subject to Fourth Amendment lawful searches. And that's not what this court held in Terry v. Ohio. There must be specific, articulable reasons to justify such an intrusion, or we allow for unbridled police discretion and the potential for a substantial and disproportionate impact on certain individual persons. We cannot allow for subjective impressions or personal prejudices to infect this calculus under Terry v. Ohio.
What do you say about petitioner's or respondent's argument that Heller itself recognizes the dangerousness of weapons?
Your Honor, I believe my time's expired. May I briefly respond? Your Honor, it does recognize that there is a danger when it comes to guns, but not an inherent danger that would justify a frisk under Terry v. Ohio. And in this case, there was no specific articulable reasons to indicate that Mr. Robinson posed any sort of threat to the police officers, but he was still frisked in violation of his Fourth Amendment rights. Thank you.
Thank you, counsel. Case will stand submitted, and the court will be in recess.
All rise. Please be seated. The court is in recess.
Please feed me, I don't care. Point me in the direction of food for you that needs something. Honestly, I felt bad. Took everything I had and nothing back. It's sad.
Couldn't say yes, but I couldn't say no.
Like, oh, that's don't do words. Oh well. It's over.
I was everyone done.
That's the response. Your Honor, everyone.
That I did.
I would have respected you. If you were gone with that, I would have respected you. I'll give it that.
Yeah. And then just say thank you.
That's it, yeah. You gotta say this more right out. I'm one eyes. It's clear. No, that. Go ahead and say anything for me in 6 minutes. Ask me a question. I think all you have to do back and forth. And he also comes like, so if they're checking like there's 9 officers already here. You don't even know. I can see myself looking over here and just hearing a voice from that direction. Sorry, that's what you were talking to me. Somebody asked me a question there. How many hours have you spent on this? Only 46. Yes, you're forgetting about the other 15 hours which don't into the actual margin.
Thank you. I definitely deserve this one. I mean,
I don't split. I think it's respectful.
bring it down.
All right, now go I can't, even on like regular days, I can't do it. My first meal is usually like, so I'm not gonna go shovel food. And I wanted to like get a muffin, like chocolate in my teeth or something. I've almost, it's almost guaranteed if I'm wearing a white shirt. I'm gonna get once he said power, I was like, oh wait, I remember there's another basic language. I guess it's right.
All rise.
Be seated. Well, it was hard, but we have decided that the petitioner is the winner. I think you both did a fabulous job. I mean, for us, so much better than most lawyers we see making arguments. Seriously. Some of it has to do with, I guess, the practice you do, but you were both so good at answering questions. It was just a pleasure. And particularly when your answer about Hiller shows the inherent dangerousness of guns, I think that's probably right. And the only problem I had with your argument was you just wouldn't admit that guns are dangerous, and they're dangerous. Judge, comments?
It was excellent, and I thank you for letting me be a part of it and share it with these wonderful colleagues. I think that the topic is so current and important that you really gave it your best efforts. The fact that it has matriculated its way through our circuit at the panel level and bank level, and it may have a future. So I think it's a very important case and critical intersection of some constitutional rights.
So, yeah, so this is a real honor for me to be here. I'm relatively new on the bench, as some of you may know, and I still can't believe I'm doing this stuff. But this really was terrific, and I'll echo what our Chief Justice said. Not only are you better than most lawyers, but I did appellate practice for a lot of years before I took the bench, and you're better than I was. One of the things that both of you were able to do that I think is a real talent that took me probably 25 years to learn, just in time for me to take the bench, is how to use the questions to springboard into your argument. That's a really tough thing to do, and both of you did it in an outstanding way. And when we're splitting hairs and deciding who won this, it really was very, very, very close and very difficult to make the choice. But you both are outstanding. You both have terrific careers ahead of you, and thank you again for the opportunity to be here. It's a real privilege.
I echo that. It was a pleasure. Thank you both very much.
Thank everyone for coming. I'm Trevor Chenoweth. I'm the president of the Moot Court Board. I just wanted to echo what George Boyle said about the interest of the topic. On Thursday, we'll be having another session over lunch, I believe in this room, where we'll have a panel to kind of discuss more in depth and take questions about the topic and this interesting confluence of different constitutional rights that we have here. But for now, I'd just like to thank our great judges for their help and support of the Moot Court Board and congratulate our competitors again.